Welcome to this explainer. All right, we are jumping right into a super fascinating real-world legal puzzle today. It's one that completely proves why the exact wording in your community documents is, well, it's absolute law. Today we're going to look at a case that highlights the massive, and I mean massive, difference between what we assume a rule means and what it literally says on paper. If you live in any kind of planned community, this is something you absolutely have to understand.
So think about this. If an association has the power to borrow money, are they legally required by their own rules to pay it back? I know, it sounds like a total trick question, right? Common sense literally screams, yes, of course they have to pay it back. But here's the kicker. Common sense isn't a legal document. This is the exact dispute that sparked a crazy David versus Goliath battle in an Arizona property owners association. And man, it really forces us to check our assumptions at the door.
Section 1. The promissory note dispute. Setting the scene.
Okay, let's set the stage here. Our dispute involves a homeowner named Joseph DeBenedictis and the Sunrise Desert Vistas Property Owners Association down in Scottsdale, Arizona. Back in February of 2012, the homeowner submitted a formal petition to the Arizona Department of Fire, Building, and Life Safety. And his main allegation? Well, he claimed that around November of the previous year, the association basically dropped the ball and failed to act on repaying some promissory notes. This actually kicked off a remarkably fast timeline of administrative legal action. I mean, by August, they were already sitting down for a pre-hearing conference.
Section 2. The association rules. The detective work.
So, during that August pre-hearing conference, the judge basically told the petitioner he needed to play legal detective. He had to point to the exact clues, the specific provision in the community's CC&Rs or the bylaws, that the association supposedly violated by not repaying this promissory note. And honestly, this perfectly illustrates the bedrock of administrative law. You can't just wave your hands and say, hey, they did something wrong. You've got to point to the exact rule they broke. The homeowner's first big piece of evidence was Article 4, Section D of the CC&Rs, which states, the association shall have the power to borrow and encumber its assets.
But the plot thickens. The homeowner's second clue was kind of buried deep in the community's bylaws. Article I, Section 8 to be exact. This section outlines the board's duties, saying they must, and I quote, pay all taxes, special assessments, and other assessments and charges which are or would become a lien on association-owned or maintained property. So the homeowner essentially tried to puzzle these two clauses together. He argued that the power to borrow automatically created a duty to repay, and that a promissory note acted as a charge that demanded payment under this rule. Section 3. The argument versus the decision. The legal hammer.
Now, what's really fascinating about this case is how it exposes that massive gap between what words literally mean and what someone just assumes they imply. The petitioner argued that, hey, the power to borrow inherently includes an obligation to repay. Makes perfect sense, right? But the judge, administrative law judge Tammy L. Egenhair, she brilliantly deconstructs this. She looked purely at the plain language. She noted that, yes, the CC&Rs definitely grant the power to borrow money. But, and this is a huge but, strictly reading the text provided, it says absolutely nothing about the repayment of that borrowed money. Basically, granting a power doesn't automatically write a rule mandating repayment mechanism. It's just not there on the page. Next, the judge completely took apart that second clue. Remember, the petitioner argued the promissory note fell under the board's duty to pay charges that are or would become a lien. Well, it all comes down to how the judge interpreted those specific words. She ruled that an unsecured promissory note is not a tax. It's not a special assessment. In fact, it's not an assessment at all. Furthermore, it doesn't even qualify as a charge under the specific provision. The judge made it crystal clear. Bylaws don't cover things that just might or could possibly occur. They cover failures to pay taxes or assessments that would definitively 100% result in a lien. An unsecured promissory note, it simply does not meet that strict literal definition. So because the exact literal text just didn't support the homeowner's assumptions, the judge's conclusion was incredibly definitive. The homeowner failed to state a valid cause of action that the court could actually adjudicate, and because of that, on September 6, 2012, the petition was dismissed entirely, over and done, no action whatsoever was required from the association.
Section 4. Finalizing. After the gavel.
Now, administrative law is incredibly strict on procedure, and getting the ruling isn't actually the final step of the journey. Once Judge Egenhair issued her decision, the Department of Fire, Building, and Life Safety had a 30-day window to intervene. During that time, they had the authority to accept, modify, or even completely reject the judge's decision. But, as the records show, they did absolutely nothing. And because they took no action by October 15th, the dismissal was automatically certified as final the very next day. From there, the only possible path forward would be an official rehearing or a formal appeal to the Superior Court. And that brings us right to the core takeaway of this entire explainer. We just saw how a completely logical assumption, that borrowing money requires a mandated rule of repayment, completely fell apart in court. Why? Because the literal words on the page just didn't support it. Assumptions absolutely do not hold up when the gavel comes down. Only the exact plain text does. Which leaves us with one really provocative and frankly absolutely crucial question for anyone living under the rules of an association. Do you actually know what is literally written in your own community's bylaws? Or are you just assuming you do? Think about that the next time you're skimming through your community documents. Thanks for hanging out with us, and as always, keep questioning what you read.